Criminal Defense Attorney Ryan Pacyga, and I'm going to talk about first-degree assault against a police officer in Minnesota state charges, which are under Minnesota Statute 609.221, Subdivision 2. I just finished a trial about this where we were able to earn not guilty verdicts for our client on all of the charges. But I want to take you through what are called the elements of that charge. In other words, what's explained to a jury or what the judge has to decide about the question of whether the government has proven its case beyond a reasonable doubt. The first requirement is that there has to be an assault, and an assault in Minnesota can happen either by causing someone fear or by causing them bodily harm. If it's fear, you have to intentionally cause the fear. If it's harm, you don't have to have meant to cause that much harm. You're responsible for the harm even if you didn't mean for bodily harm to happen. The second element is that it has to be a police officer that is on duty or doing what's required for their job. So if they're a police officer but they're just out with their wife and kids that night, that's not an assault against a police officer because they're not on duty or doing the scope of their job. And the third element is that the defendant either had to use or attempt to use what's called deadly force. And what deadly force means is that the defendant tried to cause, or there is a substantial risk of causing, death or great bodily harm. You know what death is. Great bodily harm is serious, serious injury. So it's not just a cut that's going to require some stitches or anything like that, or even a broken bone. We're talking about usually injuries like suffocation or that are going to cause problems for organs or put someone near their death, even in a coma and things like that. So you either have to try to cause it or there has to be a substantial risk of causing the death or serious bodily harm. So if you're trying to hurt somebody and you potentially hurt someone else and you're just firing into a crowd, you should know at that point they'll argue that that's a substantial risk of causing bodily harm, even to the person you didn't mean to cause it to. There are some defenses, and these aren't all of the defenses to these charges, but there are some defenses, and we used all three in the trial I just finished in order to get a not guilty verdict. Number one, self-defense. In Minnesota, you have a right to defend yourself. You do have a duty to retreat first, but if you're in your home, you have no duty to retreat. The second one is defense of dwelling. Again, in your home, you have a right to use even potentially deadly force in your home to prevent the commission of a felony. And third is intoxication. If you are charged with the fear part of the assault, intentionally causing fear, intoxication is a defense that can be used if you were voluntarily intoxicated. If you're charged with harm, then you cannot use intoxication because under Minnesota law, if you're intentionally causing harm to someone, the intoxication defense does not apply. That's because it's what's called a general intent crime, not a specific intent crime. There's a lot more to explain about that, but that's for another day. So the message is these first-degree assault charges on a police officer are very serious charges. They can wind you up spending years in prison for that assault charge if you're found guilty or if you plead guilty to it. There are defenses, and for those of you thinking, hey, wait a minute, he's out there encouraging people to assault law enforcement, that's not what I'm trying to do. But the reality is not every time somebody is accused of assaulting a police officer by attempting to cause great bodily harm or death did they actually try to do that. In this particular case, in fact, while our client pointed a gun at two different law enforcement officers, he was in his home. Law enforcement was pounding on the door in the middle of the night in the dark. Our client didn't know that it was law enforcement pounding because they didn't announce law enforcement while they were pounding. And as a result of that, when he pointed the gun at the door, we argued that he was acting in self-defense and defending his dwelling. The judge agreed, and those charges were thrown out before they even got to the jury. After that, the jury found him not guilty of second-degree assault as well because of the three defenses that we successfully raised at trial. If you have more questions about serious assault cases, I defend those. My name is Criminal Defense Attorney Ryan Pacyga. I can be found at arrestedminnesota.com or at 612-339-5844.